Now I'd like to introduce our speakers, and I'll turn it over to them. Dennis Rothschild from the Toronto office and Andrew Henniger from the Vancouver office.
Thanks, Jenny. Good morning, everybody, or good afternoon, I guess, to Dennis. We're thrilled to be here with you today. Just to introduce ourselves, I'm a partner in the Vancouver office of BLG, specializing in M&A and corporate commercial matters. I do a lot of cross-border work and a lot of technology work as well. Dennis is a partner in our Toronto office who specializes in competition and Investment Canada Act matters, both of which are the subject of today's presentation. So Dennis assists both with merger notification matters that will be discussed a little bit, as well as the multitude of other matters that are regulated under our Competition Act and under our Investment Canada Act. So we at BLG, BLG is a Canadian law firm. We're the largest law firm in Canada. We have about 750 lawyers in 5 offices across the country: Vancouver, Calgary, Montreal, Ottawa, and Toronto. In 2020, we were fortunate enough to do work for 5 of the top 10 largest companies in Silicon Valley and 9 of the top 20 as ranked by Bloomberg News. So we have a great relationship with many of you in the virtual room here, either directly with your companies or with your Canadian operations, and look forward to continuing those relationships as we go forward. So today we want to talk about, as the first slide says here, Canadian regulation of big tech. We on this side of the border see a lot of news coming out of the United States, clearly a political hot button issue for you folks. And we see a lot of activity by DOJ and other regulators in scrutinizing transactions involving technology companies for abuse of dominance or killer transactions where big tech companies, some of which are your employers, are buying up startups that would be competitors. And the landscape in Canada is significantly different when it comes to those sorts of reviews and that sort of scrutiny. And so Dennis is going to take us through some of those differences. As well, in Canada, we have a somewhat unique provision, perhaps in our Investment Canada Act, with respect to national security and protecting Canada's national security concerns. And what we have seen in that over the past couple of years is an increased level of scrutiny. So that's why we say, we've got the short arm when it comes to our competition review, but an increasingly long arm when it comes to our national security concerns. So that's what we hope to take you through today, to give you a sense of what's going on this side of the border and how it compares to some of the things you're seeing in your own backyard. And with that, I will throw it over to Dennis to take us through.
Thanks so much, Andrew. And it's a pleasure to be with all of you. I wish I was with you in person. Just to give you a little context, my whole family actually lives in the Valley. Yeah, my parents live in Los Altos, and my brothers both live in the city in San Francisco. Perhaps my finest athletic achievement was this summer. I managed to bike from Los Altos into my brother's house in San Francisco. So I hope to repeat that in the future. Maybe I can. One day I'm even going to cross the Golden Gate Bridge. But sad not to be with you in person, but hopefully in the future, soon in the future, we'll be able to do that. So as Andrew said, we're going to talk short and long arm of the law. I had to get Bernie in here because it's just something necessary for this moment in time. You can't have a presentation without Bernie making an appearance. I decided not to put him in my background. So, but what we're going to talk about today is we're going to go over kind of the 2 different buckets into which we put the short and the long arm of the law. And the short arm, we call it, is the Competition Act, which is our version of a bunch of American laws: the Sherman Act, HSR, Robinson-Patman, Clayton Act, a number of U.S. laws that ultimately are rolled up into what you would call the antitrust and consumer protection laws. So that's all within the ambit of our Competition Act. And the long arm of the law, is the Investment Canada Act. And that is, some would call it our version of CFIUS, but it's not quite. And we'll get into the distinctions in just a second. So the Competition Act is a single statute governing antitrust law. It also contains a number of consumer protection laws. Big distinction between Canada and the US that, as some of you who work at certain companies will be well aware of, in the States, there's robust state level antitrust and consumer protection enforcement. There are lawsuits that may be brought by states. States can challenge mergers. There's a whole other level of regulation on companies in the States that, lucky for companies operating in Canada, that is not replicated here. The antitrust laws in Canada are solely the purview of the federal government, and there is one agency that enforces them, and not even the strange and often confusing distinction between the DOJ and the FTC's antitrust enforcement authority in the US. We have the Competition Bureau, and they're in charge. So it's helpful for folks generally to understand that, and it's comforting in a number of ways. As I said before, number of provisions that are similar to those under different US antitrust and consumer protection statutes: cartel provisions, criminal price fixing, prohibition on false and misleading representations, abusive dominance, which is similar to monopolization in the States. It's the rough equivalent. There are some differences, but for the most part, they're very similar. Concepts like refusal to deal, tied selling, exclusive dealing, resale price maintenance, and of course, merger control. All of that is covered under the Federal Competition Act. The next statute that we're going to talk about, and which is becoming more and more important, particularly as with respect to big tech companies looking to do business in Canada, is the Investment Canada Act, another federal statute. And this gets very confusing. It's hard to describe. It's hard to understand. And I liken the statute itself. It's a little bit like the income tax. Canada, it's the Income Tax Act. In the States, it's the Internal Revenue Code, I believe. But you have to jump from section to section. It's very long and confusing. But at base, there are two separate foreign investment review schemes that are under the Federal Investment Canada Act. There's what's called net benefit review. And this is one that is not really a feature of American law. There's not really an equivalent in the American laws. And this is where transactions that exceed a certain threshold have to be reviewed and found to be likely of net benefit to Canada. The genesis of this type of review is largely a concern about the elephant south of the 49th parallel. There's long been concern among Canadians about having culture and everything they do swallowed by the behemoth down south. And so this net benefit review process allows the government, when a large Canadian company is going to be purchased, to say, hold on a second, is this going to be of net benefit to our country? I said it in reference, and the likely genesis of it was the concern about the US, but this process applies to everyone. And frankly, other countries coming in and buying important Canadian things is likely more of a concern now than it is in the US. Everybody recognizes, especially after January 20th, that the US is a friendly ally and is not somebody we should be concerned about. But nonetheless, these processes certainly apply to American companies seeking to acquire companies in Canada. So that's the net benefit review process. The separate process called national security review is a process that's somewhat similar to the CFIUS process in the US. And we're going to get into it in more detail in a bit. And that one is really where we're talking about the long arm of the law. That's the one that folks really need to look out for, particularly in present times. Just quickly, what I call scheme number 3, it's kind of a subset of the net benefit review scheme. And this is the one that deals with cultural businesses, publishing, film, music, or broadcasting. If you're looking to considering buying a business in Canada that's involved in any of those industries, again, going to the concern about Canadian culture being swallowed up by whether it's the US or other foreign countries, we're very, very sensitive to takeovers of businesses in these industries by foreigners, and they're subject to much lower review thresholds, as you'll see in a minute. So that certainly a part of the long arm of the law is if you're looking at cultural acquisitions. So to start with the short arm, the Competition Act, and to give you just some background, as you know, a number of tech-related antitrust cases have recently been brought in the U.S. These cases largely could be brought in Canada as well. They would fall under our merger control laws, abuse of dominance, monopolization, and false and misleading representations sections of the Competition Act. So just to give a little background on those, and this is more of a general overview for you, so you have some reference. And I'm not sure if the slides are being distributed, but these if they are, and I'm fine with them being distributed, that this is a kind of handy reference that you can use to think about when you might have a merger filing required in Canada. We have a very similar merger review process to the HSR process in the US, 30-day waiting period, potential for a second request that can extend that waiting period. This only applies, as in the States, to where their monetary thresholds are met. There are two thresholds, and I'll briefly touch on them, but I'm not going to go into it in great detail. If those are exceeded, then the parties are subject to this mandatory pre-closing notification, just like under HSR in the US. The Commissioner of Competition, who leads the Competition Bureau, can challenge a merger, even a non-notifiable merger, so one that's below the thresholds, within 1 year of closing on the basis that it's likely to substantially lessen or prevent competition. That's not the exact language used in US laws, but effectively the standard is very similar to that as in the US. Not going to go through this, but if you use this as a reference, this is how you decide whether this mandatory pre-closing notification applies. The key points here are asset values exceeding 96 million or gross revenue from sales exceeding 96 million of the target. If you're below that, then you can not have to worry about pre-filing or pre-notifying your merger.
Just to clarify, those are assets and revenues in Canada.
Correct. Excellent point, Andrew. Thank you. Just jumping over this is more procedural, but again, if you have a notifiable deal and there's little overlap, you can usually get it cleared within 14 calendar days. So it's fairly efficient. This is the equivalent of early termination in the US. So if you have a notifiable deal, but there's not likely to be a serious competition issue, you shouldn't be worried, again, about a long arm of the law bothering you. It should be able to get through quite quickly and with very limited issue. Not going to go into this other than to say, again, the substantive criteria when looking at a merger is similar to under US antitrust law. The Competition Bureau has been clear that they will take into account non-price dimensions of competition, things like privacy protection and the use of consumers' data. Those will be considered as potential harms to competition when reviewing a merger. So the safe harbor threshold, and I decided I'd throw in a cameo of my daughter here because I was looking up pictures of the Sydney Harbor Bridge and realized that just before COVID hit, she and I were there. So that's the safe harbor, and that's how she saw me putting this presentation together, and wanted to know why she wasn't in it. So now she's in it. Where the parties have a post-merger market share of less than 35% in any relevant market, you can expect that there will not be any real concern expressed by the Competition Bureau. You should be able to get it through quickly. Of course, the devil's in the details with market definition. As anyone who's dealt with antitrust law before knows, you have to define the relevant market before you can determine what the market share is. But if you're confident in your market definition, you can be confident that if the combined share is less than 35%, there won't be any issues that arise. One interesting difference in Canadian merger law and how mergers are looked at is that we have a complete defense to an otherwise anti-competitive merger if the parties can prove that there are efficiencies that will outweigh the anti-competitive effects of a merger. So this is not a feature in the US. They consider efficiencies, but there's no specific provision that says if you can quantify that the efficiencies outweigh the harms, then the merger has to be approved. Whereas here, we can, if the parties can show that they will achieve efficiencies as a result of the merger that will outweigh the harms that the Competition Bureau can show the merger will cause, then the merger has to be allowed. So this is one of the rare cases where you can get, on very similar facts, divergent outcomes between the US and Canada. And I won't go into it in great detail, but there was a case not too long ago in which the Bureau and the FTC came to directly opposite conclusions on the basis that the parties had shown that there were efficiencies that outweighed the anti-competitive effects. And the efficiencies, just so you get a sense of what those might be, included overhead costs, freight optimization, and the elimination of duplicate corporate services. Other issue that's becoming relatively relevant now, when there are economic issues, perhaps related to COVID or otherwise, is what we call the failing firm merger defense. If a party is looking at acquiring a party that is insolvent or soon to be or is in bankruptcy, that is potentially also a defense to an otherwise anti-competitive merger. The Bureau has to conduct a careful analysis of the financial information. And what's most important is that if you're buying a failing firm and it's going to result in what the Bureau thinks is an anti-competitive concentration, if the Bureau is going to allow that merger to proceed, they have to find that there was not a competitively preferable outcome, such as restructuring or retrenchment, a competitively preferable purchaser, or just the liquidation of the firm. So there is an analysis to be done, but it is, if we've seen it in a couple of cases recently where parties have sought to acquire competitors that were failing, and they've managed to get it through, even though it's going to lead to an extremely high market share. What's relevant and topical right now is, and I'm sure all of you have heard of it, the concept of killer acquisitions. Andrew mentioned it earlier in his introduction. There's a big move and a big push to look out for killer acquisitions, where larger players buy smaller players to prevent them from growing into a future competitive threat. The recent US complaints that have been all over the media, I claim that Facebook engaged in a series of killer acquisitions, taking out Instagram, WhatsApp, and a number of other competitors. It's a burgeoning area of the law, and we would always advise, if a client is looking at acquiring a smaller company, that we do have to think about whether the Bureau could have concerns on that basis. The only difference from the US is that in the US, they're able to challenge these deals long past their completion, such as they're trying to do in the claim against Facebook. Whereas in Canada, there's a 1-year limitation period for merger challenges. So once it's been 1 year since closing, the Bureau can no longer challenge the deal, even if they wanted to. Just interestingly, and something that we're going to see likely at some point in Canada, and I don't know if any of you have followed it, but the Visa Plaid case in the US, the parties just abandoned the deal after the challenge was brought. But the DOJ challenged Visa's acquisition of Plaid, saying that they would eliminate a nascent competitive threat that would have, absent the deal, been a serious competitor in the future to Visa, and resulted in substantial savings and more innovative online debit services. So just the quotes here, DOJ saying the merger would eliminate a disruptive and innovative competitor and give Visa a front row seat to what's happening in the fintech world, allowing them inside access to know which fintechs are more likely to develop competitive alternative payments and how to beat or buy them. This is what the agencies, including the Competition Bureau, are going to look at when they see larger companies buying smaller companies. Is there a threat that this kind of incentive is at play? And if so, they could scrutinize such a deal. So moving on from merger analysis to another part of the Competition Bureau's purview, which is abusive dominance, or the Canadian version of monopolization. So the Bureau has the power to bring cases just like the monopolization cases recently brought in the US against big tech. These provisions allow the Bureau to seek an order against a dominant firm or group of firms that engages in one or more practices of anti-competitive acts that results in a substantial lessening or prevention of competition. So when we're talking about market definition, again, the devil's in the details on market definition. The question is a firm dominant in a certain market? that's going to be the first question. If a market is defined in which a party is dominant, the Bureau can go after them for abusing that dominance. And as with, I mentioned under mergers, non-price dimensions of competition can be considered competitive harms, and that includes privacy protection and terms regarding the use of customers' data. So again, under the abuse of dominance provisions, you could certainly see a case similar to the monopolization claims made in the recent big filings in the US against Google and against Facebook. Similarly, the Bureau can challenge companies under the false and misleading representations provisions of the Competition Act for promoting their products using false and misleading reps. And representations can include ads, terms of service, or any claims made in any medium. So the Bureau has been very clear that claims regarding protection of privacy, whether in public statements, privacy policies, et cetera, can be the basis for claims under these provisions if they drive customers to use a site under false or misleading pretenses. So the Bureau can, on this basis, go after big tech in ways that are very similar to the ways that the US, both FTC, DOJ, and the states have recently come after a couple of big tech companies, and there is certainly push for more suits of this nature to be brought in the US. The Competition Bureau has been clear that they believe that they have the legal authority to do this. They have looked at and been asked to look at whether they need new powers or we need to amend our laws to deal with big tech. And the consensus from both the Bureau and from outside experts and from the bar has been that, as the Bureau said, the core principles of competition law are generally up to the task of dealing with the digital economy. In other words, they have the ability to bring cases just like the US is bringing, just like the EC is bringing, and they don't need any changes to our laws to facilitate that. To that end, the Bureau has been very, very out there and tried to be very prominent in saying that they are going to challenge the actions of big tech. They have appointed a chief digital enforcement officer, and they have, or the cabinet minister, the federal, effectively the secretary, that's the cabinet secretary at the federal level who's in charge of the Competition Bureau, has asked the Competition Bureau to look at kind of the large, quote unquote, dominant big tech companies and see how he can go after them. February 2020, the Bureau, their entire strategic vision, this is their kind of foundational policy document that they release every 5 years. The February 2020 version was titled Competition in the Digital Age. And they talk extensively in this document about making active and proactive enforcement against big tech and generally in the digital space a main focus of the Competition Bureau. So certainly sounds like there's a lot to worry about for big tech in Canada, and don't let me suggest that there's nothing to worry about. Obviously, merger review is one thing, and there is the possibility of claims, and claims have been brought. But fact is, there's no indication yet of any action, even remotely similar to that that's been launched in the U.S., seeking in both the extent of the conduct that's challenged and also in the remedies that are sought. It's not even there's not even a remote comparison. I like to say, when I criticize the Bureau in this way, just to be clear for everyone, I'm not criticizing the people who work there. They are smart, excellent thinkers. But the reality is, if you look at the budget of the Competition Bureau compared to its fellow regulators, the term drop in a bucket really applies. Canada has, just compare Canada to Australia for a second. Canada has 12 million more people than Australia, and its budget is a fraction for competition enforcement, is a tiny fraction of what Australia's is. The EC budget looks, it's still considerably larger than Canada, but it looks relatively small. But you can't forget that the EC has all its member states are also actively involved in competition enforcement. The US, the budget of the DOJ and FTC is $302 million, but that doesn't include all 50 states that are active in antitrust and consumer protection enforcement. So the bottom line is that Canada, which has no subnational competition regulator, is working from behind at a considerable disadvantage to its global counterparts in competition regulation in terms of their budget to bring big cases. As I'm sure all of you know, being in-house lawyers, it costs a lot of money to bring big cases. Even if you have a really solid case, you have to be willing to invest a significant sum. And the bottom line is the Bureau has a lot of responsibilities outside of the big tech world, and they simply can't afford to bring huge cases on a regular basis like other countries' authorities can do. The result is the Bureau has to look for bang for its buck. That is why we see that if the Bureau sees that other regulators are going after big tech companies, even if it's something that the Bureau would like to go after them for, we don't expect to see the Bureau doing much in the way of enforcement. It's effectively free riding on fellow authorities. They will, from time to time, bring effectively copycat claims that will allow them to leverage the work done by other authorities and hopefully get a fine. And we're going to talk about the quantum of fines in a second, which is relevant. You see an example that they recently brought against Facebook regarding false misleading representations about disclosure of personal information. That was a follow-on case. Beyond the budgetary constraints, the Bureau is limited in the penalties it can seek. Abusive dominance, most false and misleading representations claims have a maximum fine of 10 million Canadian dollars for a first offense and 15 million for subsequent offenses. The Commissioner of Competition put it very clearly that the maximum penalties simply lack the teeth necessary to deter anti-competitive behavior. So that is another relevant factor in why you're not seeing huge action by the Canadian Competition Bureau like you are in the US, Australia, Europe, and elsewhere. On that basis, what we're most likely to see and what I would suggest that you all look out for with respect to any business that you're considering doing in Canada is to look out for issues where there are unique effects on Canadians, issues that other authorities aren't going to go after because they're not interested or because people in their jurisdiction just don't have interest. That's a place where the Bureau is likely to focus its enforcement budget. And secondly, in the merger space, the Bureau is trying to focus on killer acquisitions, looking at situations similar to Visa Plaid or others where big companies buy up what would in the future become their competition. So that's kind of the short arm of the law in a nutshell. There's obviously lots more we could say, but I want to move on to the Investment Canada Act and talk about the long arm of the law as it emerges. And the fact that contrary to the Bureau's relative inaction, the ICA and in particular the National Security Review process is getting a lot of use and can be very difficult, frustrating for companies engaged in M&A in Canada. The criteria on which national security reviews are conducted are not defined in the ICA or publicly revealed. And even parties who are in the process, who are being subjected to a national security review, have to deal with quite a level of frustration because they are not given a lot of information about what the concerns are. It's very hard to respond to concerns if you don't know what those concerns are. And that's the frustrating situation that some investors into Canada find themselves in when they find themselves in a national security review process. And that's what the reference to a black box, and Canada's national newspaper, the Globe and Mail, described this process as being a quote unquote black box. The way that the Investment Canada Act comes up is when a party is considering an investment in Canada, you first have to determine whether this net benefit review to Canada applies. It's determined by looking at monetary thresholds that depend on a number of different factors. I'm not going to go through them all here because you would all fall asleep. But suffice to say that the key factors are whether the country of origin of the investment is a member of the WTO or a participant in other trade agreements with Canada, USMCA/NAFTA 2.0 being one of them. Thresholds differ if the investor is ultimately controlled by a state-owned enterprise. Thresholds differ, as I mentioned before, if the target is a quote-unquote cultural business. The only one, there's a couple of slides here that go into a bunch of numbers that, again, if you have a copy of this, you can refer to in the future. But what's important for all of you, most of whom I believe are working for companies that are privately held and based in the US, investors from the US will not be subject to a net benefit review unless it's of a cultural business they're buying, unless the enterprise value of the Canadian business that they're buying exceeds 1.565 billion Canadian dollars. So it's a fairly high threshold. This is not something that comes up on even relatively small transactions. However, when you're investing in a quote unquote cultural business, the threshold goes down to as little as $5 million in asset value. So you can see that the government wants to have the chance to review, for net benefit to Canada, acquisitions of businesses in the cultural sphere, even if they're quite small.
Yeah, and just you know, the definition of cultural business is something to be aware of. Dennis and I worked on a matter last year, the year before, where the business that our client was investing in was our client was taking an investment from the U.S. and their business was related to film and television, to video. And so there was a question of whether that was a cultural business. So some things that you might not think are, you need to pause for a minute and take a closer look.
Absolutely. It's a very good point. And it's certainly something that you'll want to think about at the beginning, because as I describe on this slide, where such a review is required, where the thresholds are exceeded and either one or two different federal ministers have to sign off ultimately that the deal is likely to be of net benefit to Canada. Usually that involves at least some level of binding commitments being made by the parties with respect to the continuing conduct of the business in Canada. So usually where the applicable threshold is exceeded, in order to get a deal approved, parties have to agree, for example, that they're going to maintain levels of employment in Canada, they're going to invest certain sums in Canada, they're going to have head office remain in Canada, they're going to, if it's a cultural business, they're going to invest in Canadian programming, for example, or in Canadian publishing. So if these thresholds are exceeded, it's very important for the buyer particularly to be wise to it and to think about how that might impact the proposition of the investment. If they're, you know, if they were planning to purchase a Canadian cultural business and basically strip its IP and you know, pull the business out of Canada, they may not be able to do that because the government would have to approve and would impose conditions such that that kind of restructuring couldn't happen. So it's important to be very, very careful in considering an investment if these thresholds could be exceeded. Again,
Dennis, sorry to jump in. If you could just back up one slide, I just wanted to note one thing. The first sub bullet there, that a post-closing ICA notification being required in connection with the establishment of a new business in Canada. This is something that's very easy to miss. Many of you in in-house roles may be involved in the expansion of your business into Canada organically, and you might work with tax and accountants to sort of really focus on structuring that efficiently. And then when it comes to the corporate steps, you may assume, okay, all we need to do is incorporate a Canadian entity. That's simple, and off we go. But just to point out that this notification is not only on investment or acquisition, but also on greenfielding something in Canada.
Excellent point to make. Thank you, Andrew. So when this net benefit review takes place, these are the criteria. I'm not going to go into them in great detail. Again, if you use this as a takeaway, this can be helpful. But as I mentioned before, to satisfy that there will be a net benefit to Canada, usually it requires the the imposition of conditions that ensure that these criteria will be met post-transaction. So it hamstrings the buyer a little bit. The good news, of course, going back, is in the non-cultural sphere, the threshold is over $1.5 billion in enterprise value. So it's only on the largest transactions that this is going to be relevant. I've already really covered the content of this slide. So I'm going to move on to national security review, and what I would call the big gun in the long arm of the law. And particularly given the high thresholds that most inbound private sector M&A from places like the US isn't subject to this net benefit review we just talked about. The difference with national security review is that there are no thresholds. It can be applied to virtually any investment of any value into Canada by non-Canadian, even non-controlling investments. And we've seen it recently applied to non-controlling investments. The criteria they're looking at is whether any investment would be injurious to national security, a very amorphous standard that we'll get into more in a second. But again, no thresholds applicable. Any investment can be reviewed, and the time. Very important is the time frames. And Andrew and I have dealt with this together many times. But what's important to recognize is for every controlling investment into Canada, as was covered very briefly on the previous slides, even where a review is not required, you have to file a notification form within 30 days after closing. And that notification form is usually the trigger that starts the 45-day period during which a national security review could be started. So it's only when that form is filed that the government has to start considering whether they might want to initiate a national security review. So if you file your Investment Canada Act form only 30 days after closing, the government thus has up to 75 days after closing to say that they want to review your agreement. And per this slide, on the consequence of national security review, the government can block a transaction, require divestiture if it's already completed, they can approve it, or they can impose conditions that they believe are required to rectify any concerns with national security. So you can see that if you've closed the transaction and you have a post-closing Investment Canada Act review, that is going to be usually very concerning and something you would want to have dealt with prior to closing, because that can certainly impact the value of an acquisition if suddenly the government can come in and say, well, actually, you can keep it, but only if you meet these conditions, or worst case scenario, sorry, you have to divest yourselves of this. And presumably at that point, you'd be divesting in effectively a fire sale. So it can be extremely costly not to take into account the possibility of national security review when you're acquiring a Canadian company. And we'll get into how we avoid that concern in a bit, and also what kind of deals we want to look at. And we want to have our eyes really open to that concern and make sure that we've dealt with it before closing. So as I said before, this process is thought of as a black box. The standard of would be injurious to national security is extremely broad. The government has significant scope within which to prevent or impose conditions on investments that it believes would be problematic. Even the term national security isn't defined, and the government can effectively say whatever they want national security to means. So, and that includes, by the way, concerns of allies. We have seen situations in which national security reviews in Canada are undertaken where the greatest concerns appear to be the concerns of, in the case I'm thinking of, the American Department of Defense. So they had consulted with the US DoD. The US DoD had concerns about a Canadian business being acquired by a Chinese investor, and ultimately the transaction was blocked more on the basis of the US DoD's concerns than any real direct Canadian concerns. So you can see that the process becomes very involved, and it is very broad what can be considered a national security risk.
Yeah, I think that's a good point, Dennis. We recently encountered this on a transaction in investment in a Canadian business that had a small U.S. component, but the risk of coordination between U.S. and Canadian regulators here is, it's really unsaid anywhere. But you can bet that if you're doing a Canadian deal that's only got a small U.S. piece, that you think you're below the radar, don't be so quick to conclude that, because the Investment Canada will communicate with CFIUS and its various tentacles throughout the U.S. if they sense there might be some U.S. sensitivity.
Absolutely, and you see on this slide the pre-2020 only official guidance, that really the only thing that we can officially point to as being these are what might be considered national security threats are listed here, and you'll note one of them is Canada's international interests, including foreign relationships. So it is considered a threat, or can be considered a threat to Canada's national security if a transaction might harm one of Canada's allies. And probably the most often considered ally in this respect is the US. So if there's a deal that has any US component, we do also have to consider whether the Canadian government could be worried about how the US would view that deal. And we have to take that into account in gauging what the risk of a possible national security review will be. Although this national security review process has been a definite concern and has come up a lot in recent years, in April of 2020, it became an even greater concern when the government released an official statement citing the unique and extraordinary circumstances of the COVID-19 pandemic, and announced it would be subjecting certain foreign investments into Canada to enhanced scrutiny. The basis for this was concern, just to put it frankly, it was concern about largely Chinese companies coming in, taking advantage of sudden valuation declines related to the pandemic, swooping in and purchasing Canadian. Really, the biggest thought was with regard to precious resources. But the way it's being applied and the way the government, both in practice and in the official statement, is the government is not just going to apply enhanced scrutiny to things like buying gold mines, which they've recently blocked the transaction of a Chinese company purchasing a Canadian gold mine, but they are using these national security review provisions to look more closely at any investments by foreigners into Canada related to public health or involved in the supply of critical goods and services, or by any state-owned, influenced, or even closely tied to foreign states. So probably not an issue for most people on this call, but I would say that virtually any inbound Chinese investment has to at least have a very, very close look prior to entering into a transaction as to whether a national security review is likely, because the reality is the Canadian government takes the position, rightly or wrongly, that effectively any Chinese mainland controlled companies, and we can discuss whether Hong Kong controlled companies may fall into this ambit too, but the government is of the view that pretty well any large Chinese company is subject to a fairly high degree of Chinese state control. And the government is being very clear that they are going to use these national security review provisions to look very closely at virtually any acquisition like that. But possibly of more relevance to the crowd on this call is related to public health or involved in the supply of critical goods and services. They are also looking at private sector acquisitions of anything related to public health, anything related to supply of critical goods and services, and that includes infrastructure, roads, electricity, energy, anything of the sort. Not saying that by any stretch all investments in these areas are going to be subjected to national security reviews. They are still relatively rare, but it is. If there's one thing that you take away from this call, and I think Andrew can back me up in dealing with his M&A clients, is that when you're investing in Canada in anything that could be considered remotely related to public health, critical goods and services, high tech, anything of the sort, you at least need to look at it and talk to a talk to somebody here who's experienced in the Investment Canada Act process to consider whether that's something that you should take into account in your acquisition.
That's right, Dennis. And I think there's still a bit of a learning curve that the M&A world is getting up in terms of what this risk profile looks like and how it's changing. And, you know, it may not be a case where your deal is actually blocked or subject to you know, onerous conditions, but it might be that the government starts taking a look at more transactions. And so the last thing you want to have happen is that you get that letter post-closing and you say, this is a serious problem. You want to do the analysis up front to say, you know, is this a transaction where we need to condition our closing on getting clearance under the Investment Canada Act, or do we just take a long look at what's going on here and reach the conclusion that, you know, based on the facts we have and advice of experts, that we're willing to go forward and you know, quote unquote risk a national security review after the fact. But it's definitely something that is becoming a bigger part of the conversation. Obviously, sellers of businesses are loath to put in any conditions, but buyers need to just have a sober pause to consider it.
Absolutely. Really, I've covered this, so I'm just going to skip over this slide, but just to get to kind of some of the substance of recent concerns that will be of particular relevance to big tech and where you want to, again, really, I think the right advice is that any acquisition in Canada, you should at least consider it, whether you should ask the question, is there a possibility that this could trip us up? But recently there's been talk of and attention paid by the folks who administer the ICA to telecom and electric infrastructure, the exposure of sensitive data to potentially malicious foreign actors, transfer of personal information to hostile foreign actors. Again, that one is perhaps more of a concern for non-American investors. But again, the nature of the process is such that they want to look up to the highest levels. So if there's an American-based company that is ultimately controlled by a Chinese or a Russian or even a Middle Eastern state, that may be the basis for concern from an Investment Canada Act perspective. And it's something that, again, your counsel will help you take into account before you get into the deal, so you can gauge the risk and take appropriate measures to prevent the risk. As I said, the actual number of reviews are very rare. Now, as you see on these stats here, in 2018, 2019, the national security process was commenced 9 times. We don't have the stats yet for 2019, 2020, but expect that I would be surprised if it isn't double that for the next year, because they have increased the scrutiny. But if you look at when it happens, the process was commenced 9 times. Of those 9, 4 of the deals didn't survive. Only 3 of them were approved. 3 were approved, 2 were not approved, but 4 deals were either withdrawn or parties were ordered to divest of interests that they'd already acquired. So getting to how we deal with this, obviously there's an entire advocacy process once the process is commenced, by which we try to clear the deal and ensure that if a national security review is started, that you fall on the side of review commenced but allowed to proceed. But the way that we can protect you up front is to make sure that if there's any question about a national security review potentially being commenced with your deal, we strongly recommend that the deal be structured so that the time period during which a national security review could start would be expired as a closing condition, meaning that either the 45-day period after filing an Investment Canada Act notification has elapsed, which means a national security review can't start, or if a review did start, the process has been completed to the buyer's satisfaction before they have to close. So that is a failure to include that in an agreement where there's a potential national security review might not be an issue because the review might not happen, but it could be quite a difficult outcome involving post-closing divestitures and other very costly matters that you don't want to have happen, and it is quite easy to prevent if you structure the deal appropriately. So, subject to any questions, that I managed to my own shock, get through it reasonably quickly. So I'll turn it over to Andrew for any concluding remarks he may have. And if there are any questions, I don't see any in the chat, but folks are more than welcome to pop in with them then. I'll just wrap up my portion by saying that if you do take one thing away, it's that the Investment Canada Act concern is big and it's growing, and it's something that you always need to look at when you're considering any sort of investment in Canada by a foreign company. And been a pleasure, and look forward to chatting with some folks over lunch. And I'll turn it over to Andrew for any concluding remarks and any questions that may have come in.
Yeah, thanks, Dennis. That's great. My message largely echoes Dennis, that this is something to put on your radar as a preventative measure for sure, and then appropriate action based on the facts of your transaction. Want to invite you all to reach out to us if you are contemplating either an acquisition in Canada, or, as we mentioned, if your company is in the process of opening the Canadian market as an organic growth initiative. We practice exclusively Canadian law, have great relationships with a lot of U.S. firms, so are more than happy to cooperate with your U.S. counsel that exists and work with them in whatever supporting role is appropriate. It's been our pleasure to be here, and I'll leave you with one uniquely Canadian note today. Today in Canada is a special day called Bell Let's Talk Day. It's an initiative that was commenced by one of our telecom operators, Bell Canada, 5 or so years ago, to really shine a spotlight on mental health issues and to be a big fundraiser nationally for mental health initiatives. So in 2020 and 2021 in particular, these things are more important than ever. So just want to leave you today with encouraging you that if you're feeling great, that's fantastic. Pick up the phone, reach out to a friend, family member, colleague that you've been meaning to call, see how they're doing. If you're not feeling great, same thing, pick up the phone, talk to somebody. We're all going through a lot of struggles in 2021 and 2020, and I just want to take the opportunity to shine some light on that today in particular and every day. So thanks very much.
Thank you all.